Greetings, everyone, and thank you for joining today's session covering some recent developments in English intellectual property law and their practical implications for in-house IP teams. I'm James Whitaker of Whitaker Law, and it's a pleasure to welcome you today. It won't surprise anyone to hear that we're living through a period of profound and rapid change in the way intellectual property rights are created, protected, and challenged. Technological innovation, international legal shifts, and the growing impact of artificial intelligence have all converged to create a dynamic and sometimes very unpredictable legal landscape. So in today's brief session, we'll take a look at some of those recent developments in English intellectual property law and their practical implications, the impact on the management of IP portfolios, including, for example, reassessing trademark and patent protection in the post-Brexit era, addressing AI-generated works and content and combating online infringement, and how these can be approached and managed. The slide outlines the key topics I want to cover, albeit somewhat briefly. So let's start with Brexit, which continues to have a profound impact on intellectual property rights, IPR, and IP litigation as well. As you'll recall, the UK officially left the EU back in January 2020, and the transition period ended at the end of that year. During that transition, IP rights remained largely unchanged. Following early 2021, when the Trade and Cooperation Agreement came into provisional effect, there has been a gradual shift and divergence from EU law. The agreement, the Trade and Cooperation Agreement, essentially set the current levels of IP protection applying in the EU as the baseline to which both the EU and the UK remained committed, rather than applying anything new. A key development was, of course, the Retained EU Law Act, which came into force in January of 2024, which critically abolished the supremacy of EU law, meaning that English courts no longer have to follow EU precedents. This could lead to a distinctly English approach to IP disputes as the years go on. So far, however, courts have mostly continued to align with EU case law, but again, this may change over time, and this needs to be closely watched by IP teams to see how that divergence comes into play. An early example of this legal shift was seen in the industrial cleaning equipment case from a couple of years ago, where the Court of Appeal chose to depart from EU case law for the first time in an intellectual property matter. This perhaps indicates that judicial divergence from EU precedent may gradually increase as we move forward.